Welcome back to the Deep Dive, where we unpack complex ideas to give you those essential aha moments. Today we're diving into a topic that might sound a bit dry at first, international finance and law. But trust me, its real-world impact is anything but. Have you ever paused to think about what happens when a major company operating in multiple countries suddenly hits financial icebergs? It's not just a local bankruptcy, it's a ripple effect across borders, impacting investors, employees, and entire supply chains worldwide. Our mission today is to pull back the curtain on a critical piece of South African legislation, the Cross-Border Insolvency Act 42 of 2000. We're going to explore its purpose, its key mechanisms, and most importantly, why it's so vital for keeping our global economy running smoothly. Whether you're a curious listener keen to understand how the world works, or maybe a law student looking for practical clarity, this deep dive is crafted for you.
Indeed. And this act, which actually saw some updates as recently as October 2024, it's South Africa's robust answer to a very modern global problem. How do you handle financial distress when it just doesn't respect national borders? It's a powerful example of international cooperation directly shaping trade, investment, and even individual livelihoods right here at home.
Okay, so let's set the stage then. Why did South Africa even need a dedicated Cross-Border Insolvency Act? Don't we already have laws for companies going bankrupt? What gap was this designed to fill?
That's a fundamental question. And you're right, we do have comprehensive domestic insolvency laws, but they often struggle when a debtor has assets or creditors or operations scattered across different countries. Each country has its own rules, right?
Right.
And without a harmonized approach, these situations can quickly devolve into a chaotic scramble. It gets messy.
A scramble, yeah, I can imagine.
And what's truly fascinating here is the global push behind this. The United Nations General Assembly, way back in 1997, actively recommended that countries look at their cross-border insolvency legislation. And South Africa wasn't just a passive observer, we were actually a co-sponsor of that resolution. We threw our support behind the UNCITRAL Model Law on cross-border insolvency.
UNCITRAL.
Exactly. So this isn't just a South African idea popping out of nowhere. It's part of a concerted global effort to bring some order to potential international financial chaos.
So it's really a piece of a much larger global puzzle then. Given that, what were the specific problems South Africa aimed to solve by adopting this model law? What was the actual why behind it all?
Well, the Act's preamble lays out the needs very clearly, and these are direct, real-world impacts. Imagine a scenario, maybe a tech startup based here, but with major venture capital from the U.S., manufacturing in China, maybe a dev team in India.
Okay, yeah. Common setup these days.
If it collapses without this Act, those international investors, those employees, they might face a labyrinth of conflicting laws. Total loss is a real risk. So this legislation aims to, first, strengthen cooperation between our courts and foreign authorities, cut through the red tape.
Makes sense.
Second, provide greater legal certainty for trade and investment, makes businesses feel safer operating internationally.
Right, predictability is key.
Third, ensure fair and efficient administration of these complex insolvencies, protecting all creditors and stakeholders, including the debtor themselves. Fourth, protect and maximize the value of the debtor's assets. You want to stop them being sold off piece by piece at fire sale prices.
Preserve value.
And crucially, fifth, to facilitate the rescue of financially troubled businesses, which in turn protects investment and preserves jobs. It's about trying to save what can be saved,
That really does highlight the incredibly high stakes involved. So diving deeper, what's the core purpose of this act? What does it actually do?
At its heart, the Act provides effective mechanisms for handling these cross-border insolvency cases. Simple as that, really. It also amends our existing Insolvency Act of 1936 to better regulate the jurisdiction of our high courts in these international contexts. It's basically about building a bridge between different legal systems.
A bridge. Okay, I like that analogy. To fully grasp how that bridge works, we need to clarify some key terminology. We often hear about foreign main proceedings versus foreign non-main proceedings. What do those mean exactly? And why is that distinction so important?
Absolutely crucial distinction. Think of foreign main proceedings as the headquarters of the insolvency. This is where the debtor has the center of their main interests, of their primary operational hub, where most decisions are made, maybe where the bulk of assets or operations are.
The nerve center, basically.
Precisely. In contrast, foreign non-main proceedings would be more like a branch office. It's where the debtor has an establishment, but it's not their central base of operations.
And what defines an establishment in this context? Is it just having an address?
No, it's more substantial than that. An establishment isn't just a mailing address. It means any genuine place of operations where the debtor carries out a real ongoing economic activity, with actual people and resources, essentially a mini business presence. And this distinction really guides how much power and scope a foreign representative will have here in South Africa.
That makes perfect sense.
Okay.
So this isn't a blanket law then. It doesn't cover every single foreign insolvency that might have some distant connection to South Africa. How broadly, or perhaps narrowly, does this act actually apply?
You've hit on an important point there. It's definitely not a universal net. The Act has a specific scope of application. Section 2 lays this out. It applies, for instance, when a foreign court or representative asks South Africa for help, right?
Okay.
Or, conversely, when a South African representative needs assistance in another country. It also kicks in when there are concurrent insolvency proceedings for the same debtor happening in multiple countries.
Messy situations.
Exactly. Or simply when foreign creditors want to participate in proceedings here in South Africa. And here's a critical safeguard. This act only applies to a foreign state that has been officially designated by our Minister of Justice.
Designated? How does that work?
Well, the minister can only designate a country if they're satisfied that the foreign state's law offers reciprocal recognition to South African insolvency proceedings.
So it's a two-way street. We help you if you'll help us.
Precisely. It has to be mutual. And this designation also needs parliamentary approval. That builds trust and mutual respect right into the system's foundation.
That's a smart way to ensure fairness, definitely. But what if something requested by a foreign court fundamentally clashes with our South African legal principles? Is there a safety valve?
There absolutely is, and it's a vital one, the public policy exception, Section 6. Our courts can, and frankly should, refuse to take any action if it would be manifestly contrary to the public policy of the Republic.
Manifestly contrary. Okay, that's a high bar, but it's there.
It is. So while we embrace international harmonization, our national values and core legal principles remain paramount. That's non-negotiable. And interestingly, when interpreting the Act, Section 8 specifically tells our courts to consider its international origin and the need to promote uniformity globally. So there's that tension.
Right, balancing local values with global cooperation. So I've covered the why and the what. Now let's move into the practical how. Let's imagine that scenario. A big company in, say, Germany goes bankrupt. But it has significant assets, properties, bank accounts, maybe even IP right here in South Africa.
Yeah.
How does Germany's insolvency representative even begin to deal with those South African assets under this act?
That's precisely what Chapter 2 of the Act addresses, facilitating access for foreign representatives and creditors to our courts. And it's a bit of a game changer because a foreign representative has a right of direct access to a South African high court to seek relief, Section 9.
Direct access, so they don't have to navigate complex diplomatic channels or find local proxies first. They can just come right to our courts.
Exactly. It cuts through a whole lot of traditional bureaucracy. It streamlines things significantly.
Wow, that sounds incredibly efficient.
It is. And to protect them, there's a key provision, Section 10, granting limited jurisdiction. Simply applying under this act doesn't automatically subject the foreign representative, or the debtor's foreign assets for that matter, to the general jurisdiction of South African courts for any other purpose.
Okay. So they aren't opening themselves up to unrelated lawsuits just by showing up.
Precisely. It's a focused, specific interaction for the purpose of the insolvency only.
That makes sense. What about the creditors themselves? Are foreign creditors treated differently from local South African creditors? Does the act show any bias?
Not at all. The Act really champions fairness and equality here. Section 13 is clear. Foreign creditors have the same rights as local creditors. That means the same rights when it comes to starting or participating in South African insolvency proceedings.
Okay, same rights.
And critically, their claims can't be ranked lower than non-preferent claims. That means they won't be pushed to the very back of the queue just because they're foreign.
Non-preferent claims. Remind me what those are.
Those are essentially your general unsecured creditors. People owed money but without specific collateral tied to the debt. Think suppliers, maybe some service providers. So foreign creditors get treated at least as well as them. It ensures a baseline of equitable treatment.
Got it.
Plus, Section 14 lays out explicit requirements for notifying foreign creditors about proceedings here, deadlines for claims, where to file, that sort of thing. Transparency.
Okay, so the process seems quite open. If a foreign representative wants their insolvency proceedings formally recognized here, what's that formal application process like? Section 15, I assume.
Exactly. Section 15 covers the application for recognition. It's central to the whole process. The foreign representative needs to provide proof. a certified copy of the decision commencing the foreign proceedings and appointing them, or maybe a certificate from the foreign court. Acceptable evidence.
Standard legal stuff.
Pretty much. They also need to be transparent and identify any other known foreign proceedings related to the same debtor. Full disclosure.
Right. And does the Act help speed things up?
It does, yes. To make things efficient, Section 16 includes some clever presumptions. For example, the court can generally presume documents submitted are authentic unless there's evidence otherwise. And crucially, the debtor's registered office or habitual residence is presumed to be the center of their main interests, which, remember, is key for foreign main proceedings unless proven otherwise.
So that presumption helps establish jurisdiction quickly.
Exactly. It avoids lengthy arguments about where the main proceedings should be unless there's a real dispute.
And then the court makes a formal decision to recognize under Section 17. What are the potential outcomes?
Well, if the foreign proceedings meet the criteria, they're genuine insolvency proceedings, the applicant is a legitimate foreign representative, it's brought before the competent court, then recognition must be granted.
Must be granted.
Yes, subject, of course, to that public policy exception we talked about in Section 6. That's always the ultimate safeguard.
Right. The public policy backstop.
The court will then specifically recognize them either as foreign main proceedings or foreign non-main proceedings based on where that center of main interests or just an establishment is located. And the Act stresses this decision should be made at the earliest possible time. Speed matters here.
Okay, speed and clarity. Once a foreign proceeding is recognized, or maybe even before, if things are urgent, what kind of relief can a South African court actually grant? What are the immediate practical implications for assets sitting here in SA?
The Act allows for immediate action, which is crucial. Even before formal recognition, under Section 19, if there's an urgent need to protect assets or creditors' interests, our courts can grant provisional relief.
Provisional relief, like what?
Could be temporarily stopping anyone from executing against the debtor's South African asset-seizing property, for instance. Or it could mean entrusting a foreign representative on a temporary basis with the administration or realization of specific assets here. It's like hitting the pause button to prevent things from getting worse while the formal recognition process unfolds.
A crucial pause button, I imagine. And here's where the power of this act really seems to kick in. Once foreign main proceedings are formally recognized, Section 20 talks about immediate and powerful automatic effects. What exactly happens then?
This is a significant legal impact, yes. Upon recognition of foreign main proceedings, certain actions are automatically stayed, halted.
Automatically, without needing a specific court order for each one.
Correct. It includes the commencement or continuation of individual lawsuits concerning the debtor's assets. And any execution against those assets, it all just stops. Even the right to transfer, encumber, or otherwise dispose of any of the debtor's South African assets is suspended.
Wow, so it basically freezes the situation locally.
Precisely. It prevents a free-for-all, stops individual creditors maybe racing to grab assets located here, ensuring a more orderly process where, hopefully, all creditors get a fair shot.
That makes a lot of sense. And beyond these automatic effects, what other relief can a South African court grant once foreign proceedings are recognized, whether they're main or non-main? What's the scope of its discretion under Section 21?
The court has broad powers under Section 21 to grant any appropriate relief it deems necessary. The goal is always protecting the debtor's assets or the interests of the creditors. So this could include staying actions not already covered by that automatic stay we just discussed. It could involve taking evidence or even entrusting the entire administration or distribution of assets here in South Africa to the foreign representative.
Entrusting the whole lot.
Potentially, yes, but always with the critical proviso that the interests of creditors here in South Africa are adequately protected. That's paramount. Section 22 covers this.
The protection aspect. Section 22.
Yes, protection of creditors and other interested persons. When our courts grant or deny any relief under this act, they must always be satisfied that everyone's interests, including the debtors, are adequately protected. The court can also impose specific conditions on any relief it grants. Tailor it to the situation.
Okay. And does the foreign representative get any teeth? Can they actually chase down bad deals?
They do. Section 23 gives them standing. Foreign representatives are empowered to initiate legal actions to set aside acts detrimental to creditors, things like voidable preferences or undue preferences. Basically, they can step into the shoes of a local liquidator to claw back assets or undo unfair transactions that happened before the insolvency.
So they have real power to act locally.
Absolutely.
This sounds like a lot of intricate legal choreography across international borders. How do courts and representatives in different countries actually work together? How do they coordinate to ensure everything runs smoothly? Is there a formal mechanism for cooperation?
That's the absolute essence of Chapter 4. Cooperation with foreign courts and foreign representatives. It's fundamental. Section 25 mandates it mandates that our South African High Court shall cooperate to the maximum extent possible with foreign courts or foreign representatives.
To the maximum extent possible. Strong wording.
Very strong. And this cooperation can happen directly, judge to judge, or through a local trustee or liquidator acting as an intermediary. They can communicate directly, share information, request assistance. It's about breaking down those traditional barriers between national court systems. It's about being a global team player.
So it's not just the judges. Our local insolvency practitioners, trustees, liquidators, they also have this explicit mandate to cooperate. Section 26?
Yes, absolutely. Section 26 mirrors it for them. South African trustees, liquidators, judicial managers, curators, whoever is appointed locally must cooperate to the maximum extent possible, always subject to court supervision, of course. But they, too, can communicate directly with foreign courts or representatives.
So everyone's supposed to be talking to each other.
That's the goal. If we connect this to the bigger picture, this whole extensive framework for cooperation in Chapter 4, including communicating information, coordinating administration, approving formal cross-border agreements under Section 27, it's all designed to create a truly functional, internationally harmonized system. It's about preventing legal silos where courts in different countries work in isolation, potentially leading to asset stripping or inefficient outcomes. It aims for a coordinated, fair process overall.
Okay, coordination is key. But this brings us to what could be the trickiest part. Chapter 5, concurrent proceedings. What happens if there are insolvency proceedings running in both South Africa and, say, Australia at the same time for the same debtor? How does the Act handle this potential for a legal quagmire?
Yeah, this chapter is specifically designed to address that potential for chaos and conflict. The Act outlines clear mechanisms for coordination. Section 29 is key here. For instance, if South African insolvency proceedings are already underway when an application for foreign recognition is filed, any relief granted under this act must be consistent with what's happening in our local courts.
So the local proceedings aren't just ignored.
Not at all. It's about making sure the two processes can work together, or at least not actively undermine each other, making sure the two captains on one ship are trying to steer in the same direction.
Right. What stands out here is, does the foreign proceeding automatically take precedence? Or is there a careful balance struck?
It's definitely a balance, and Section 29 provides clear guidelines for the courts. For example, if foreign main proceedings are recognized after our South African proceedings have already commenced, then that automatic stay we discussed under Section 20 would likely be modified or even terminated if it's inconsistent with how the South African proceedings are being run.
So the court has discretion to adapt the relief.
Exactly. It's all about coordinating effectively to achieve the best, fairest outcome for everyone involved, considering both proceedings. Another powerful tool in this chapter is Section 31, the presumption of insolvency.
Presumption of insolvency. How does that help?
If foreign main proceedings are recognized here, that recognition is, in the absence of proof to the contrary, considered sufficient proof that the debtor is insolvent for the purpose of commencing South African proceedings.
So it avoids having to reprove insolvency locally.
Precisely. It greatly streamlines and speeds up the initiation of local action if that becomes necessary or desirable.
Very efficient. And to ensure fairness across all creditors globally, what if a creditor has already received some payment in a foreign insolvency proceeding? Can they then just turn up here and claim the full amount again? Seems unfair.
It would be. And Section 32 addresses that directly with the rule of payment in concurrent proceedings. A creditor who has received partial payment on their claim in a foreign insolvency proceeding cannot receive further payment for the same claim in South African proceedings regarding the same debtor, as long as other creditors of the same class or rank in the South African proceedings have received proportionally less on their claims.
Okay, so it prevents double dipping.
Exactly. It ensures a more equitable distribution of the debtor's worldwide assets across borders. You get paid based on your total claim, not based on where you happen to file first.
But it doesn't affect secured creditors.
Correct. The rule makes clear it's without prejudice to secured claims or rights and rem rights over specific property, like a mortgage holder's right over a building. Those specific rights are usually preserved. It keeps things fair for the general pool of creditors.
This has been an incredibly insightful deep dive into South Africa's Cross-Border Insolvency Act. Really fascinating. It's clear that this legislation is far more than just, dry legal text. It's a living framework. It provides order, fairness, and certainty in our very interconnected global economy. From facilitating cooperation between courts to protecting creditors, ensuring assets are managed effectively, it's really designed to bring structure and predictability to what could otherwise be utter chaos in international business failures.
Absolutely. And this raises an important question looking forward. The Act provides a robust framework, clearly born from international collaboration via that UNCITRAL Model Law. But its ongoing effectiveness will rely heavily on continued judicial interpretation by our courts, practical application in complex, real-world cases, and adaptation to the constantly evolving landscape of global commerce.
It has to stay relevant.
Exactly. It truly is a testament to the idea that law must continuously keep pace with economic reality. It can't be static.
Absolutely. And it seems to elegantly balance South African legal principles, like that public policy exception, with these crucial international norms, ensuring our fundamental values are protected while still fostering essential global cooperation. It really feels like a cornerstone for navigating these global financial storms and providing that necessary safety net.
Well put. It aims for that balance.
So for you, our curious listener, here's something to mull over, a provocative thought perhaps. How might this act, by providing a predictable and fair framework for dealing with business failures across borders, how might it subtly influence and maybe even encourage new international trade and investment decisions? Does the certainty it provides, knowing there's a clear process for financial distress rather than an unpredictable legal maze, does that embolden businesses to expand globally? It's something to ponder as our world becomes ever more interconnected, isn't it?
A very interesting point to consider, definitely, the downstream economic effects.
We hope this deep dive has given you a much clearer understanding of why this seemingly niche law is actually so vital for global commerce and legal practice. Whether you're just a general enthusiast trying to understand the world, or maybe you're diving deep into legal studies. Thank you so much for joining us on the Deep Dive.